those individuals who wish to speak in favor of TA 14-1 to please approach the lectern. And for the second time, I would ask those individuals who wish to speak in favor of TA 14-1 to please approach the lectern. And for the third and final time, I would ask those individuals who wish to speak in favor of TA 14-1 to please approach the lectern. At this time, I would ask those individuals who wish to speak in opposition of TA 14-1 to please approach the lectern.
Good evening, Commissioners, Chairman. I'm Judy Jones, 335 North 8 Mile, Casper, Wyoming. I'm speaking tonight against the changes in the zoning resolution pertaining to the natural expansion doctrine, especially the deletion of the section pertaining to private use. That is currently included in the expansion doctrine of at both the county level and the state level. Mr. Knight told Planning and Zoning and the public it was at the direction and the request of the Board of County Commissioners to the Planning and Zoning to make this deletion of the section of the zoning resolution. In other words, it wasn't their idea. The Commissioners also advised Mr. Knight in Planning and Zoning was essentially to pass their commission to delete this section controlling the non-conforming use properties. Okay, I'll talk more about that in a minute. Passing this deletion would thereby eliminate grandfathered rights of private property owners who are not businesses. Example, like myself and my husband, who simply store on their properties cars or something else. They don't run a business off their property. Right now, as it is today, the county nor the state or federal laws make no such distinguished difference in the uses, whether it be business or private use. They have a right to expand to their full use of their parcels of land that are grandfathered. The county commissioners and the county attorney are both trying to say that only businesses have the right to expand. This could not be further from the truth. Mr. Knight asserted this stance at trial and lost his argument in district court. It was struck down by Judge Sullins, and Judge Sullins said, whether it be a business or a private use, the state law is as well as the current resolution protects both private and business expansions. The point here is this is a state law, and I think we all know now that state laws override county laws, contrary to what Mr. Knight and Ms. Malone are telling you. This commission on several occasions have had a chance to look at my decision from the court, I hope. Mr. Knight probably showed it to you after the verdict came down, and then I gave you a copy a couple of weeks ago. According to our own decision by Judge Sullins, he agreed that this county cannot stop Jones from expanding on his 10 acres as long as it's the same use prior to zoning and its status as an original 10 acres. We also know that we can't buy the property next door and expand our 10 acres and our use to it. I actually believe to insult our intelligence, the judge's intelligence, and everyone who is involved in their understanding of the laws governing the natural expansion doctrine shows a lack of both understanding the decision and a lack of comprehending your roles as commissioners. This is nothing short than a slap in the face to the district court's decision and the citizens of this county and state. I have a question. For what reason is this even being revisited? Is because some of you guys are still harboring ill feelings towards losing in district court. But this is why we have courts, to decide such issues. And it would seem the district court did decide. It may not have been what you wanted, but it's the facts. Is this really what you want to tell the public, and you want them to think that because this commission failed to act and accept on our offers and negotiations, and that we had to sue in district court to get a conclusion? You cannot rewrite state laws and change a decision of a district court, no matter how many delete keys you use. I take great offense to this commission for misleading the public in our case alone. Some of you said we refused to work with you, and that is plainly a bald-faced lie. We gave several offers to this commission in several occasions over the last 3 years prior to filing our lawsuit against this commission. The commissioners all refused our offers and instead making a joke about it by saying openly, we will just let him take us to court. This is what we faced with this commission, petty, biased, personal hatred. One in particular said, opening that we were hillbilly junk hoarders, and another called us a sore thumb to the commission. Need I remind this commission it was Mr. McDowell and Mr. Opella who wanted adjudication in a courtroom. We simply beat you to the punchline. Well, you got it sitting in front of you tonight. 19 pages of how many ways this county attorney and this commission violated my rights. According to Mr. Knight's own statements in planning and zoning on 7/15/14, the change is being sought and requested from you, this sitting commission. Based on statements by Mr. Knight in that meeting, Mr. Knight actually said it was because of the Joneses case. When asked by one of the planners, Hal Hutchinson, he asked, why are we even going back over this? What's wrong with it? And Mr. Knight told him basically it was because of Dana and I that they wanted to basically close the loophole up. This is at best showing a clear lack of learning anything from the decision in my trial. That this commission is again trying to eliminate something out of existence that could not be done by this governing body. You're messing with state laws. The loss this board suffered in District Court 01214 must evidently lead you to believe by deleting this section of the resolution, it will then allow the county commissioners to take control over other non-conforming use properties. Simply by using the delete key, and it magically stops a man's right to expand on his property of his non-conforming use. This could not be further from the truth. I won't argue the legalities of it here. I'll let attorneys do that. I will say that Judge Sullins made it quite clear in his decision in my case. You cannot deny a man's right to the use of his land, full use of his land, the entire parcel. Let's address another statement made by Mr. Knight, 715. He didn't understand this section very well. It wasn't clear for him. I find this almost laughable, since Mr. Knight is fully aware of this section, and he argued against it in District Court in November 2012 and lost. He himself said he read it 1,000 times, but yet now claims he doesn't understand it. This is vague at best, he says. We evidently, Judge Sullins understood it, my attorney understood it, I understood it, Mr. Brown understood it, Mr. Hutchinson understood it, Harold Wright understood it. So what's the problem now? Why don't you understand it? The fact that the planners, Jim Brown in particular, said, and I quote, I understand and see nothing about this that needs to be addressed. It's clear, simple, and I fully understand it. And agreed this needs no work at all. This should be a clear message to this commission that to change this would not only fail if it was challenged in a court, it would lead people of this county to believe you're doing this as a means to attack other non-conforming properties. Because why else would you be doing this? You can bet if you pass this and delete this section of the zoning, my district court decision will be used again and again by anyone you try to take to court. It's on file in district and it's readily available to anyone. My point to this is your county attorney is not advising this commission for planning and zoning properly. He seems to cherry pick sections of both state laws and county resolutions to fit his particular needs. His misrepresentation has cost both us and the county thousands of dollars in years of litigation, and many nights and days of emotional distress that it should have never happened. It's a matter of, does this board really want to rehash what is a 19-page decision from the 7th Judicial Court? The property owners do not have to be a business to be protected under this doctrine. The answer is no. The district court's decision has said this, and so does many other cases, laws, and reference material used all over the country and Wyoming. And then the next part. Now, is it this commission's plan to test each and every one who makes this claim in a court of law? If it is this commission's wish to try to strip people of their constitutional protections and our own state laws, then you're going to be some busy boys in and out of courts, getting your hands smacked every turn, attempting to do this. You will be tying up the court systems for years to come on a fact that has stood the legal test of time and rulings. I've given you all copies of that decision, and it's a work of art. It's protection of grandfather use as non-conforming properties, whether it be business or private. To continue this attack on non-conforming use property owners seems more to satisfy some bruised egos instead of something to help settle various opinions of how this should have been handled. Even looking at this in a good light, at best it seems like it's just pure retaliation by this commission because of my victory, and yet another attempt to rewrite state laws, or perhaps target others who may or may not have financial abilities to fight back as I did. As Mr. Keating said one time, it's your job to do the right thing. Well, explain to us tonight just exactly what the right thing is. To take more people's rights, to take them to court, to try to gain control over something that is clearly not in your control as commissioners, to continue costing taxpayers thousands of dollars in future legal battles over the same issue, and maybe some of them will have to fold because they don't have the ability to fight. Now, the last part of this, I'm going to talk to you a little bit about your planning. The planners assured me after I spoke to them at the meeting it wasn't their idea, so I don't know who's claiming that, but they're full of it. It was somebody who's on this commission board or somebody who's on this commission board. We all know it. It's common knowledge. So, because Jason was standing up here and he's like, well, I can't even explain the natural doctrine. So how is he going to do anything with it if he doesn't even understand it? Okay, last but not least, missing documents in their planning and zoning. Again, your planning and zoning is a mess. Your resolution is a mess. Take a look at your land use plan that KLJ just did. It's even worse than the first one. You have missing documents, photos, no traffic studies in a lot of these developers that are coming down. But let me get back on target here. You've got a planning and zoning board, and they're supposed to be your advisory. Well, if they're just doing what you're telling them to do, they're just figureheads. And in my world, it's called co-conspirators. So I would urge you tonight to stop trying to change a decision by Judge Sullins and rewrite the state law. The constitutional implements alone would stop most intelligent men. I don't care what Mr. Knight tell you, he's wrong. The county does not have the power to change or erase Judge Sullins' decision or my verdict. Thank you.